You're live.
Okay, well, welcome back, folks. That
That
was a false alarm for what anyone out there that's watching. We have confirmed that the system is being tested by the Capitol Police and it has been false alarms, but we did act as we. So let's quickly get back to earn time.
Yeah, and so then the final portion is just notice and record keeping. DOC also has to provide timely notice, not less frequently than 90 days to offenders who receive a reduction in their term. And then DOC has to maintain a system that documents and records all earned time reductions in each offender's permanent record. And again, the big question is, well, why are we doing this? Why are we talking about earned time right now? And if you look at the PowerPoint from the first meeting, one of the things that this committee has to do is review the current earned time program and whether it should be expanded to include parolees, as was a topic of discussion in the House Corrections and Institution Committee from this past session, as well as permitting earned time for educational credits for both offenders and parolees. And again, because parolees are not currently included in the earned time program. And then a second portion of this review concerns the DOC's victim notification system to examine its current operation and effectiveness and whether it has the capabilities to handle any such expansion to include either educational credits or to parolees under the current program. And then that testimony needs to include the DOC, Center for Crime Victim Services, victims and survivors of crimes, including those who serve on the center's advisory council and the Department of State's attorneys and sheriffs. So that's the focus of the committee as it's going through the review of the program is, should it be expanded to parolees? And then should educational credits be a new program offered to both parolees and sentenced offenders? And basically, can the victim notification system handle this?
Oh, we need lots of time on this. And my committee spent a tremendous amount of time on this because the thinking was if you could incentivize, right now, what is happening within DOC is go down that rabbit hole of presumptive parole, because we've got that going on too. But what is happening is parole is under the parole board. It is not under DOC. DOC supervises. Furlough is under DOC. So when earned time was put in, because furlough is still under DOC and they're considered incarcerated, though outside the walls in the community, they should qualify for earned time. The same as for folks who are incarcerated. Parole is a different situation because it's up to the parole board to make those decisions if someone is paroled. What has been happening is people are not wanting to go on parole. They want to go more on furlough so they can get earned time. They're not getting earned time on parole. Furlough and parole would only be effective or eligible once a person's met their minimum. So the thinking was from some of our colleagues is if we could offer incentives for folks to receive earned time or earn extra time off their sentence if they're involved in an educational program, a college program. My committee started talking about apprenticeships, internships to get back in the workforce. Well, the initial thinking is, well, you could do that just for folks who are on parole. Once you start looking at it, well, why wouldn't that be offered to folks who are on furlough? Why wouldn't that be offered to folks who are incarcerated? So it kind of has this domino effect of something that may look simple on the surface gets really, really complicated when you get down to the nuance. So then it was kind of left for us to make a recommendation. How, if we expand earned time, number one, do we do it? Do we expand it? Do we expand it to those on parole? Do we do it with having some educational credits available. So they might earn a little bit more time, work opportunities, apprenticeships, and interns. And then the other piece, of course, is the victim notification piece, because in earned time, what's really an issue is in the victim arena, they are sentenced, and they are sentenced for X amount of years in the min and X amount for a max. And then you calculate in earned time, their sentence is going to be less, which then raises the anxiety level of many victims. So then if we expand earned time to more categories, what does that do to a person who is a victim? So we got a lot of layers. But and the other thing, if we do expand anything, DOC is going to have to update their rules. Or is it a directive or a rule?
No, it's a rule.
It's a rule.
Has to be a rule under this.
Administrative rule, so they're going to have to update all of that. So that's what's before us.
When you say if we do expand it, is this committee actually expanding it or sending it back to the committee of jurisdiction?
It's
Okay.
a recommendation. We don't have the authority to expand.
Yeah, essentially what was decided is to have the committee explore to kind of keep momentum behind the idea. Now there was a bill drafted or a version of a bill. I don't know if that's something you want me to bring to the next,
What we did in my committee.
right? About the educational credits and then all that. It didn't necessarily address, it's just a way to do it, not the way.
So
Mhm.
we'll get some testimony on this.
We're gonna have to get a lot of, that's why I wanted
The
to.
numbers,
Yeah.
I don't know, the Victim Resource Center, we're gonna
Yeah,
hear
we're
somebody
gonna
there.
have Jen.
And then
And specific victims.
the resources available to oversee and help implement,
And the parole board.
and the parole board. Yeah.
And I just want to clarify the portion where Josh was helping me out. So it was offenders that are serving a disqualifying offense after 2021 don't earn good time. Before then, they could have.
Wait a minute, how do we do that? How do we do that? Because that was done.
No,
It's in the
How's
statute.
that done? It was,
yeah,
I think
Hmm.
but the issue was when we first put earned time in place, regardless of what the offense was, anyone that was incarcerated or on furlough, except for the big 12,
no, but it was everybody.
it was everybody. And then the victim community was really upset because they said, wait a minute, this person was sentenced 8 years ago, and this is what the sentence is. Now you've changed the rule of the game. And particularly for these offenses. So we spent the session in 21, we were all on Zoom, trying to figure out. So I think it was when it was effective,
Yes.
So
the
if-
law became effective going forward, anyone who was on those statuses.
Right. So what?
That's the team of the bill,
Yeah,
but it said very specifically, if you were sentenced for one of those disqualifying offenses
On January 1, 2021, you shall not earn any earned time sentence deductions under the section after the effective date. Subdivision 5, which is that the provisional reading from should not be construed to limit or affect earned time that an offender has earned on or before the effective date of the act.
so they
they're like-
wouldn't lose their earned time.
Right, they got like 4 or 5 months.
Right, but going
between-
forward.
But going forward, if they were serving, they wouldn't. But then again, anybody sentenced after that, and I believe the thought was that for somebody sentenced after that, the victim could be made aware, the court would be aware that this sentence that you're imposing may actually be less.
And while I wasn't there during that time, the other issue that I could see is that there's a due process issue here. Since people were essentially potentially meeting the requirements of the earned time program prior to it being effect. So why would they be excluded as opposed to others? So there is a little bit, and that's something that this committee and the committee of jurisdiction will probably have to deal with. If you just.
For those carve-outs, for the
For
carve-out?
parolees. For parolees especially, it's more of a significant issue, I would imagine, than sentence offenders because they have a different status. They're subject to the rules of the parole board.
Right. So that's what we're gonna have to do. But people need to understand just the basic fundamentals of earned time that they receive 7 days, not up to, but they receive 7 days a month, provided they don't have a major DR. Basically,
And they haven't violated their condition.
haven't violated their conditions while they're out on furlough. So that would track if we expand it to parolees. But the ultimate decision, if a person's pulled back into a correctional facility or not, it's up to the parole board, not the OC.
What happens if persons earn time and then they reoffend? Does any of that earned time, they lose it all, or they?
They've earned it, so if they reoffend, it's a new
It's a different case.
case, and they could have a new sentence. If they're
Still on parole?
But right now, earned time doesn't affect parole, so this would all be things.
Oh, okay.
But if they're on furlough,
If they're on furlough,
Furlough.
because you can't kind of use one case to adjudicate another, you know, they're kind of separate.
Yeah,
so they would have, if they have a new charge, it's a new offense, they have a new charge. They still have their current conviction and sentence that they have to carry through. And then they're going through the process for a new charge. Now, that new charge, they could be held as a detainee, or they could be out on conditions.
And if they're sentenced for that new charge, kind of their behavior from the past can be factored into that new sentence, but it can't be done the other way around.
And then.
So if they,
I'm thinking of a person that offends while they're on furlough.
Mhm.
So doesn't it revert back to the sentence they had?
No,
No, it's a new charge, it's a new crime, it'll be a new sentence.
right,
So
so
under that-
they would be arraigned separately for that.
They're arranged separately, it's a separate conviction. So they could be serving 2 sentences. One sentence could be for 10 years, another sentence could be for 5. They could be serving that consecutively or what's the one?
Concurrently.
Concurrently. That's where it gets really confusing when you're looking at DOC now.
Yeah,
But once you earn that time, essentially, it's yours away.
You can't take away earned time.
Once it's been earned.
again, and that goes back to that due process issue.
It's really complicated. So you think it's easy to expand it to parole? It's not. And you may think it's really easy just to say, well, for some incentive for people to succeed while they're on parole. If they're involved in an educational program, let's up the amount that they've earned on earned time. But then if you don't do that for folks who are on furlough or incarcerated, you've got a population that you're treating differently.
And then you have due process or even equal protection issues.
So it got really complicated, so we punted to us.
And a quick sort of primer on what's kind of colloquially known as learned time, not earned time for the education credits, is that you get a certain amount reduced off your sentence to say if you got a trade certificate, or maybe some more if you got a bachelor's degree, or even more if you got a master's or a professional degree. So that's kind of the idea behind the educational credits, is that if you've essentially used your time either in prison or under the auspices of DOC, productively by getting a degree or getting some training, that's something that should be credited towards your sentence. That's the general idea.
We're gonna have to spend some time on this next month. Our meeting next month is the 16th of October, 16th, right?
16th.
So we bumped out Medicaid waiver as well as the healthcare, so we're gonna do that. Then we're gonna have to, testimony on earned time, which would be from the victims community, Jen, and the parole board, which is George, is the chair, and
He's asked, so Tim again.
Mary Ann Ainsworth, Ainsworth, and DOC.
Tim from PSAS, they're involved in that too.
Dumont.
Yep.
It's our state's attorney. So we're gonna have to spend a lot of time on that one.
Do you want me to bring in or at least submit the previous bill version? Okay.
Yeah, get a good start. Because we may need the November meeting to make further recommendations, discussions, testimony. So Marshall, you came in, what do you want to do here, folks?
I need to leave.
I need to leave.
I-
And after 3
I will
years.
volunteer that I don't have anything terribly substantive to contribute. I'm happy to. You guys have,
Thank you.
and thank you for trying to accommodate me.
Yeah. Thank you. And we'll go over our schedule to see what other things we may need to do, but I think the medical thing is gonna take a long time.
No, I mean, from a purely
Not the Medicaid waiver, but understanding what we've put in place.
prescription and opioid use coverage.
Yeah, because we've put in quite a bit in
As
place.
far as committee work that needs to be done, it's only the pretrial supervision stuff, which the committee's already voted upon, and then the earn time issue. The rest are either reports that are submitted, and then you digest and kind of do what you do. And then anything else that you'd like to bring to the table.
So I don't want to have this cramped schedule next time, but
No. We should get it work done.
want to do the earn time first and then the medical. Did we try to also have well path around
Yes,
for the medical?
yes.
Okay, anything else? Interesting.
Thank you.
Anything else? So we'll see you all on October 16th.